Hey, good morning, incubator students. It is Monday, March 23rd. Hope you had a good weekend and you're good to go and refreshed up and ready to start your next week of online learning. Um, I know that this is probably challenging for you guys, so just hang in there. We're doing good. All the lesson or sort of the feedback that I got from everybody meeting with everybody last week, we're in good shape. There's one or two of you that I probably haven't checked in with your team as much as you should have. So make sure that you're not the speed bump in your team and you are pulling your weight. If there's a team activity, you need to call in and work with your team and pull your weight. So those grades will be much more heavily weighted individually because of that moving forward. So just mind your stuff on that. All right, so let's get on with our lesson for today. Today's an easy one. We're going to be going on with part 3 of our legal, in which case we're going to be moving forward with intellectual property. Sounds boring, but it's actually really cool. So you'll need these slides from 6.3 number 2, and then these resources right here, number 6 and 7 as well. So we're going to do number 2, 6, and 7 for your resources today. So let's go through to those slides here first, and then we'll get to where we need to be moving forward. All right, I'm going to make this full screen. There we go. That's better. Get me out of the way here. So intellectual property involves a lot of different things. In theory, though, it's really about protecting ideas and concepts, some of which are tangible. You can get your hands on them, some of which are not. They're just thoughts and ideas and concepts or art, music, whatever the case may be. So by definition, the U.S. Congress shall promote the progress of science and useful arts by securing the limited times to authors and inventors that the exclusive right to respect to the respective writings and discoveries. So basically, the government at some point stepped in and said through the Bill of Rights and said, hey, these people are inventing stuff. It doesn't have to be like a physical, tangible thing, but it's still inventions, and those things need to be protected. So let's go through what those might be and how that affects your business. So there are 5 different types of categories or types of intellectual property. They are trade secrets, design and utility patents, which we'll get through, copyrights, and trademarks and trade names. So let's go through each of those real quickly. You can skip this one. And all right, so there's lots of different things that happen in the news when we talk about intellectual property. And why is it important? Because it's huge money, right? So Apple and Google have been in fight in courts for years over billions and billions of dollars back and forth and say, who had the first touchscreen? And no, Apple did, nor Google did. And like who owns what and how does that sort of the technology behind that? And they just keep going back and forth and suing. And I think that's going to be in the courts for the rest of your life. So there's just tons of examples, and all you got to do is just search intellectual property news, and you'll find a ton of examples out there. And the reason that exists is because there's so much money behind it, right? So they want to be able to protect their business and their ventures. So trade secrets is the first one. When we think about trade secrets are basically anything that might be like formulas, plans, ideas that gives a business a reason to keep it a secret. So, for example, the formula with Coca-Cola. iPhone, what are they on the iPhone 10 or 10X or something? It doesn't matter. They're probably already designing the iPhone 11 and the iPhone 12 and the iPhone 23. Like all those sort of things are already in design. They're always a year or two ahead of themselves. And it's really important that they protect themselves and make sure that stays internally and it's not shared and it's not made public. That could go the same for, clothing ideas or food ideas or music ideas or marketing plans or whatever the case may be. So much so as if you start working with a company that has intellectual property stuff that they need to be working through, you will sign a contract that says, you don't get to disclose that to anybody. And if you quit or if you're fired, you can't even go to a competitor. And if you do, they'll sue you. So even their employees sign contracts and stuff about making sure that stuff stays secret. It's a big deal. Some of them last a short period of time, 15, 20 years. Others, like the Coca-Cola formula, that is protected for 125 years. So there's lots of different things out there that'll do that. And they will do that with the protections to protect their assets. Pharmaceutical companies are famous for this. So, you can get generic versions of Tylenol and aspirin because it has passed the trade secret deadline of 20, 25 years or whatever that case may be with the patent and other things as well. Others, you can only get the brand name of certain medicines because that company owns that product, and they want to keep those under secrets. And so there's lots of examples out there. You just got to do a quick search. So reverse engineering, is that legal? So for example, one of the favorite places that I like to go to is a place called Acoustic Cafe. There's one in Eau Claire and one up at UW Stout in Menominee. And for years, like I've driven across the state to get one of these subs. It's really ridiculous. Every time we go up there, we come back with a cooler full of them because we're so addicted to them. They're amazing. I don't know what they put in them. It's probably something illegal, but we can't have enough of them. So if you're ever up in Menominee, Eau Claire, go get a sub from there. Acoustic Cafe, amazing. Anyways, what if I was a restaurant here in the Valley and I wanted to sell subs, and I just copied their formula, their magic, because there's some sort of like a olive oil vinaigrette sauce in there that just, wow, it makes you mouth water. Can I reverse engineer that and sell it as my own and call it something different, right? Is that possible? Can I just buy a new Tesla car and come up with the exact same version of that just by buying their car, tearing it apart and saying, oh, that's how they built it? Is that legal? The answer is kind of. Probably not. It depends on if that company wants to sue you or not. But typically the answer is they'll come after you. So when we think about patents, right, patents sort of fall into that same category. A patent is basically the protection of an invention or design, okay? A utility patent is how my phone works. Right, so this is the utility patent about how it works and the makeup of it and the engineering behind it. The design patent is based off of how it looks, right? There we go. So design patent, how it looks, the aesthetics, the non-functional design, ornamental part of it. The utility patents is how it works, the guts and the mechanics of it. Typically, that is granted for a 20-year period. So if I design a new tool, right, that for a toolbox for a mechanic or something like that, I can own the patent design on that for 20 years. After that 20 years expires, you can either reapply for it if you've tweaked it a little bit, which companies do all the time. Otherwise, it would just become what's called public domain. But your patent basically protects you that. To get that, you have to apply to that through the U.S. Patent and Trademark Office, uspto.gov. And it's not the easiest and most cost-effective process to do, but it's important. There are patents officers and lawyers and stuff that'll guide you through that process. So this phone, the question is this covered by a utility patent or a design patent? I'll pause where you think about that for a second. Did you say both? Yeah, you're right. It is. It is covered by both the utility and design patent. So the design patent covers the way that it looks, the way that it feels, and the utility patent covers the way that it works. Patents for them to work need to be novel and new and cannot be an improvement on a prior work. Cannot have been on sale for more than 1 year prior to application. So you can't have this idea, run with it, sell it, and then 2 years later and say, man, I wish I would have patented this. You missed your window. You got to do it right away. And there's what's called a provisional patent application, which basically says, hey, we know that you are applying for this patent process, and this may take a few months for us to get through the system. So you have what's called a provisional patent, and then once it's approved, then you'll have the full patent. You'll hear about that a lot when you talk to people, when you watch Shark Tank, and they're like, oh, yeah, we have a provisional patent on this, which means it's in process. So who owns the patent? The employee, or the person who invented it, or the employer? Point in case, pull-ups. So true story. So I grew up in Neenah, Wisconsin, and one of the major companies in Neenah was Kimberly-Clark, who makes pull-ups. And my good friend of mine, Chris Surprise, yes, that's his last name, Mr. Surprise. His mom was an engineer and designer for Kimberly-Clark. She invented this product out of my buddy's underwear. Technically his underoos, which were basically like cartoons on underwear. It was a thing in the 80s, just trust me. She got nothing from it other than her continued paycheck. The company made billions off of it because she signed a contract that anything that she invented while working for Kimberly-Clark was property of Kimberly-Clark, and that's her job to invent stuff for the company. So In that case, that would be the scenario. Even if she thought of the idea, quit, and then 6 months later says, boy, I'm going to come up with this new idea. Kimberly Clark said, nope, you probably would have had that idea by working for us, so we still own it. So you have to be really careful about that. Let's go back to the slides. Copyrights. So switching from patents to copyrights. Copyrights are basically protecting anything that is intangible. So you got your written works. So like if you write a book, movies, if you write or direct the movie and own that movie, software, music, things like that. Copyright protects you against all of that. As soon as you write it, you own it, which is pretty slick. One of the links that's in here is called Creative Commons. And this applied to one of our teams from last year, but I don't think this would apply to this year. No. Creative Commons allows you to really quickly license your product for free. A lot of my lessons that I have created and share with other teachers are licensed under Creative Commons. That way I'm legally protected and I won't have to worry about the details. Let's get back to our slides. So copyright exists as soon as you publish it on your own and you create it, you now own that copyright. You just got to make sure that you can always prove that it was your idea originally and you didn't lift it from somebody else, which then gets into the issues of like, hey, your song sounds like my song, I'm going to sue you, like the whole Led Zeppelin thing, or Blurred Lines with Pharrell and that other guy, Alan Thicke. No, that's his son, Robin Thicke. They got sued by I can't remember their name. Anyways, look it up. Not the video though, it's inappropriate. And there's all sorts of copyright issues out there for music and software of like, you stole my idea, blah, 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 that sort of thing. Again, because it's big money. To register that, again, you just got to publish it, and who can prove that it was made first? So that's why it's nice to always copyright and trade and get your stuff published with a time and date stamp. Trademarks are basically logos, right? So anything a logo based, whether it be a consumer product in the grocery store or the Apple logo or whatever the case may be, you always want to make sure you trademark that. I've trademarked stuff for previous businesses of ours. It's not that hard. It costs about $1,000. You just got to send in all the artwork and proof and any variations that you ever may use, whether it's black and white, larger sized, in color, that sort of thing. So any variations you have to make sure you have to covered. That's what this little R means down here, registered trademark, which means that you cannot use that logo or design or any likeness therein for a product similar to that. Can be something completely different and apply, but in that case, you couldn't do that. So I could open up Acoustic something else, but I can't call it Acoustic Cafe and sell subs because they own that. If it's a completely different industry, then you'd be fine. So there's trademarks versus service marks. Trademarks are for products. Service marks are for like a dry cleaner. It's not a product, it's a service, right? They identified the source of the product, and protection comes typically within geographic area, which one of the things our groups 2 weeks ago learned is that Quick Trip is actually protected only in Wisconsin, Minnesota, and I think Ohio. A different company with a Q, yep, it's a true story, look it up, owns the original Quick Trip, and they granted territorial access to our states. So there's that. Let's see, Lanham Act, that we can skip. And this we can skip. Okay, so trademarks, again, there's always counterfeits that are going out there. Like you can see with this purse, that sort of thing. Hopefully you don't have any like fake Oakleys or a fake Gucci bag or something along those lines or whatever this stuff is. Any things that you find, you would be able to typically, you'd have to sue them and say, hey, we own that, and then they have to pay up the penalties and stuff like that. Interesting stuff. Trademarks can be lost, and they can be misconstrued. So, for example, the Google, which is a trademark, is now also a verb, right? To Google something. Same with like Kleenex, right? Kleenex is it's a Kimberly Clark brand again out of Neenah. But how many people say, do you have a tissue? Most people usually say, do you have a Kleenex? Aspirin, escalators, kerosene, zipper, all were original trade products, which are now more sort of ambiguous product or category product names. All right, so there's some other examples here that you've got your resources for. This document is going to be really helpful with you in doing your work for today. So above and beyond looking at these slides, so go back through those slides, you've got this document you're going to be able to go through that provides you some additional information about the different type of property, what's protected, the terms of protection, and any comments. You've got some fees to do so, what it costs to do trademarks and copyrights and all sorts of things. These don't account for paying a lawyer to do it. These are assuming you're doing it yourself. If you're going to put a lawyer on there, figure a couple $100 an hour above and beyond. It gets expensive really quick. So your job for today, and this is individually, this is not as a group, so individually, you are going to take this quiz right here, quiz on intellectual property activity quiz, and it's this guy. So read the scenario about an app that my lawyer friend and I, yes, that's his real name, EJ, is my buddy, is the lawyer. We decided to come up with a patent for an app that we created. This is not true. The names are true. The idea is not. And you need to identify with each one of these, is it a trademark, utility patent, design patent, trade secret, or copyright? Some of them may be one, some of them may be multiple. So it's check all that apply as necessary. And there's 8 there. If you finish it and you bomb it, it'll tell you your score right away. Do it again. If you don't like the score, do it again. It takes you 7 times to get the score you want. Awesome. That just means it took you 7 times to learn it. If you figure it out on the first time, that's great too. So do it until you get the points you want. That way you'll learn. And then I'll put in the scores on Tuesday. Any questions? Type me up. Send me a message. We can do a hangout or whatever the case may be. But have this done for Tuesday. See ya. Wash your hands.